executive level employees. Oh, okay. Executive level employees through the Rose Group regarding California and federal employment law issues. Mr. Rose's other services include workplace investigations, serving as an expert witness, employment law training and auditing of employment policies and procedures. And he has served as a mediator in legal disputes and as a judge pro tem for the California Superior Court. Ken attended one of our previous MCLEs and volunteered to do a session for us on workplace investigations, which is always, I think, the most fun part of practicing employment law. You get to hear everyone's different side of the story, put the puzzle pieces together, and help employers reduce their risk. And Ken is an expert at that. So really looking forward to this presentation. And Ken, I'll turn it over to you now.
All right. Well, thank you very much. Let me kind of begin by how did I get into workplace investigations? I get a little bit about my background. As you can see from the color of my hair, I've been around a while. In fact, when I was in law school, the president of the United States was Richard Nixon. That's how far I go back. And when I started practicing, and I've always practiced in the area of employee law, if you want to put it that way. But at that time, when I started, it was strictly labor law, union management relations, employment discrimination. Title VII was still in its very early stages, still developing. They had become an issue, but not really that developed. Wrongful termination, there was no such thing. Sexual, quid pro quo sexual harassment, let alone hostile environment, sexual harassment, that wasn't even in the terminology. That did not exist. And then it take a sort of fast forward. I started my own practice about 15 years ago, and this was after I had spent a number of years with firms, including as a partner at the Littler firm. And I had never actually done a third-party workplace investigation until I started my own practice. But once I started my own practice, it was really an area for me to get work to do, because the law firms that represent businesses in employment matters know that they cannot be a witness and also be an advocate in the same case. And so they became, in a sense, my referral sources. And I developed the practice. Initially, it was a solo practice. I really didn't have the conflicts. And then at some point, my son had finished law school, had practiced for a few years on the East Coast, and then he joined me. And so together, we're a firm of two people. And because of our size, we fill these niches, such as workplace investigations. And our referral sources tend to be the law firms that don't want to do the investigations. And as Alexa said, they are fun things to do. I really enjoy them, and it is my favorite part of the practice as well. Let me begin with the first slide, and what I call legal considerations. And while I was preparing for this presentation and doing the slides, and I thought to myself, we tell clients all the time, hey, you got to do investigations. It's required by law. It's mandated by law. And I must say that it's reached a point where I'd kind of forgotten, well, what is the foundation of all of that? What is there a particular statute, is there a particular regulation that says, or a particular court case? So I had to go back and do the research. And sure enough, I mean, it's right in FIA, it's right in the regulations. And as you can see, the regulations indicate that the investigation, and it's just key words, fair, timely, thorough, due process, reach reasonable conclusions. So I taught myself something, and sure enough, the other part is that that's what has to be in the policies. So when you do the investigations, it's not only the legal considerations themselves, but the employers also have to be, uh, cognizant that their own policies commit them to do investigations, and sometimes in a certain matter. Next, is really what is the legal significance of investigations, and in what role do investigations have played in litigation over time? And the key case here, and I remember this is a 1998 case. I remember when this case came out, this Cotran case, very famous, a California Supreme Court case. And the holding in that case is that the investigation does not, it cannot be second guessed by a jury if the investigation is done in a fair and appropriate manner. And the fact pattern in that case was that Cotran was a supervisor. He was sued, or the allegations were made against him of sexual harassment. The company investigated for the Supreme Court decision. It sounds like the Supreme Court felt that the investigation was, done in a stellar way. Yet and then based on the investigation, the company decided that or the investigation concluded there was harassment, and the company decided to terminate Mr. Cotran. At the trial court level, the trial court instructed the jury that they can make their own finding on harassment. Cotran's cause of action was an implied covenant of good faith, and the jury went ahead and found that there was no harassment and awarded Mr. Cotran a fairly large sum of money for that time. The Supreme Court ruled that no, that the trial court erred. The trial court should not have allowed the jury to second guess the conclusions of the investigator, provided that those conclusions were reasonably reached, and that the company's decision to terminate Mr. Cotran based on those conclusions were reasonably reached. I also put in here a case where the investigation seriously backfired on the company. In that case, it was United Airlines. And in that case, one of the really bad facts was that this Mr. Nazaire, who had been terminated following some allegations against him of misconduct, when those allegations were made, the investigator that United Airlines appointed was someone who was in Mr. Nazaire's chain of command, and who Mr. Nazaire had made previous complaints about that guy of harassing him. And so you can imagine that the investigation had a lot of flaws, beginning with who was chosen as the investigator. And so the investigations can be used to help a defense, but it can also be used by the plaintiff to kill a defense. In terms of best practices, it really start when there is a retention. And I've done, I'd say that at this point, I've probably done, upwards of 150 investigations. If I had to count it, probably interviewed 1,000 witnesses. And every investigation comes with its unique qualities. But there are certain practices over time that I've developed, and the retention part, I think, is very important. First, I would say that in terms of the investigations, that by and large, they are referrals from the company's outside employment counsel. And moreover, the companies we do investigations for, we usually have had absolutely no relationship whatsoever. We don't know the people, we don't know the company. In some instances, unless it's a sort of a brand name company, we haven't even heard of the company. And that is something that I think I've been able to successfully use during interviews when I've had witnesses who were kind of weary of who are you and who do you represent and why should I talk to you? But to basically explain to them that, look, I'm coming into this cold, and I will do this with the complainant too, if the complainant's the first witness, because I want to find out more about how the company is formatted and where the complainant falls within what department and so on. A key here is availability. I would say every time we get contacted about doing an investigation, it's not next week, it's not 2 weeks from now, it's yesterday. And in our firm, there's two of us. It's my son Robert, myself. He's a very experienced investigator too. And one or the other of us will take the investigation, and whatever else we have going on, we'll figure out a way to get started. We will never tell a client, no, we can't do this for 2 weeks or so. They want someone right away, and if we can't do it, then they're going to find somebody else. So being available is very important. In terms of the initial intake, you want to get a good round of information, sort of to figure out what's going on, what's the nature of the complaint, maybe who are the major players, what the company has done in terms of investigation at that point. What's always concerning in those initial conversations is to make clear to whoever I'm talking to, whether it's often it's someone in HR, don't tell me your opinion of the complainant. Don't tell me your opinion of the accused. I don't want to be influenced. And you have to handle that obviously very gingerly. But it's very important to me that I need to go into this fresh with an open mind and not with, being told that the complainant or the accused has certain characteristics. That's something that I will have to determine. Important question is whether the complainant and accused are actively employed, on leave, or former employee. Obviously, if they're no longer employed, there's a greater barrier to interviewing them. I will ask the company to provide me with someone who's sort of neutral to the issues in the investigation to be my contact person. Contact person is very important because I don't want to initially contact witnesses. I wouldn't be very comfortable if someone picked up the phone and called me and said they wanted to question me about X, Y, and Z. And so I'd like to have the contact person basically help me schedule interviews, contact the person who I want to meet with, including the complainant, could be the accused, and let them know so that they have a heads up, and then I will take it from there. The contact person is also someone as the investigation proceeds, and I need documents. Please, would you please find these documents for me and send these to me? Then, as you see at the bottom of the slide, the engagement agreement and the attorney-client privilege. Let's go on to the next slide, because the attorney-client privilege in investigations, when they're being done by the attorney as a third party, those are really crucial matters in these investigations. Our engagement agreements do state that the relationship between our firm and the employer we're doing the investigation for is an attorney-client relationship. And the purpose is to preserve the attorney-client privilege for the company. Because it's their privilege, it's their privilege to waive, not ours, but we enter into it formally, there's an attorney-client privilege. However, we assume from the minute we start the investigation that everything we do is transparent. Every communication we have, our notes, our outlines, emails, the reports, everything could see the light of day, because if things go in a way that the investigation is used in a manner to make an adverse employment decision and there's litigation, it's likely that the company is going to use the investigation in some way in its defense. And once it does that, it effectively does waive the privilege. And I point to the WellPoint case as being one of the principal cases that's often cited, that if the employer is going to use the investigations and the conclusions of the investigations to make adverse action decisions, then if there's a challenge to that decision, the adequacy of the investigation comes into play, and therefore a lot of privileges go away. In this same regard about the attorney-client privilege, I put in here just a heading without even any bullet points: minimize contact with the company's regular outside counsel. Very important. The reason the company's outside counsel is not doing the investigation, and we are, is not because they don't have absolute competency to do the investigation. They do. They know how to do it just as well as we do. But we were brought in because we're a third party, and we're not going to be the advocate if there's any litigation that arises out of the issues that we're investigating. The company's counsel that we work where we get referrals from, they understand. They understand that they have to not communicate with us, and that if they do, and if there's a litigation, whatever communications we had with them could be non-privileged communications and have to be disclosed. And I would say by and large over the years, the company, its regular counsel, they don't call us like every week, what's going on? How's it, what's the state of the investigation? What were you told? That they understand, they wait, and then it's really, we bring them back in when we're ready to do the report. So obviously the investigation, the primary part of the investigation, or our time, is devoted to doing interviews. And then there's a lot of time that I will spend getting ready for the interviews, collecting some documentation, and I want to get some better understanding of the company, because as I say, most of these are businesses or sometimes public employers we have nothing to do with. We've never dealt with them before. And you want to understand the structure. You want to understand how things are organized. One of the documents that I will always request is an org chart that shows where the complainant works, what the structure is. I will ask for the policies. Of course, we will if they're written complaints, I will want to see those, regardless of how they were sent, whether they could be informal emails, they could be formal written complaints, they could be the notes taken by the HR department when someone complained verbally. An important part of the way I do business, or the way I do these investigations, is my chronology. I like to have a chronology that gets everything together, because often you start getting documentation, there are a zillion emails, there are a zillion text messages, and sometimes it's very hard to put them, which came first and so on. And so I start to put things in a chronological order, and it makes a lot of sense for me. And my chronology is sort of like a living document. Each time I get some more stuff, I fix the chronology, I edit it, I add more information. They're very helpful. The investigation plan is my next point there. My investigation plans tend to be more flexible. I don't have a rigid, this is the way I'm going to do every investigation. I have enough experience that instinctively, based on the information I'm provided, I'm able to figure out how I want to proceed. And in each investigation, may be a little different. And as things go, and you meet with more witnesses, I get more information, the investigation plan could expand. What I use in the interviews are some forms. I use two interview forms. One I call ground rules, and the other I call acknowledgement. At the beginning of the interview, I use the ground rules form. It's a very short form. It's 1 page, and it basically says, who I am, that I've been retained by, make it clear I'm being retained by the company. And if they ask, I make it clear, yes, I'm being paid by the company. I tell them I'm, investigated a complaint, doesn't identify what the complaint is. Make it clear I'm not their attorney. And I explain to them the process that I take, which is I take notes. I take very, very detailed notes. I still do most of my note taking handwritten. And I explain to the witness, and this includes the complainant, includes the accused, that at the end of our interview, I will read my notes to you verbatim, because I want my notes to accurately reflect what you told me. And when I go through the notes with you, I want you to be very aggressive with me if I've missed anything. If I've written anything down that's incorrect, I will correct it. If there's, basically sometimes you go through the notes and the witness goes, okay, now, yeah, I can, that makes me think about something else that I didn't tell you. Bring that up and do that. And I actually do, and you look at my notes, there's circles and arrows and so on and crossouts. But I feel comfortable at the end of the interview that my notes accurately reflect what I was told by the witness. The form I use at the end of the interview and after I have gone through the notes is called an acknowledgement form. And that too is a very short 1-page form. It basically says that I treated with the witness with respect, but most importantly, it says that I did in fact go through the notes and that I gave the witness the opportunity to essentially tell me what I've written down that was wrong, what I needed to add, etc. Then my next point here is about preserving evidence and an investigation file. And this is, obviously is kind of a no-brainer. We're all lawyers. We understand documenting and retaining good files. And let me tell you, it's really key. When you have investigations that you've done that become a factor in later litigation. And, the litigation is years after the investigation. And, you kind of forgot. I mean, I've had a situation recently where I had to prepare for a deposition in a case where I did the investigation almost 3 years ago. And what I was able to do was go back to my files and go through my files, everything, including not just the reports or the draft reports, But my interview notes, my chronology, the documents that I reviewed, the emails that were exchanged, etc. And I must say that I felt pretty good about myself because when I went through it, everything was what I felt was documented very well. And it allowed me to, do the recalling exactly how the investigation proceeded, what I had looked at, why the information in the report was put in the report, what the findings were. Um, and again, I just say that the documentation is important because it's not what you're going to need tomorrow. It's possibly what you're going to need 2 to 3 years from now. Okay, in terms of the interview process, if you look at the first bullet point, I read the quote, "The good, the bad, and the ugly," the Clint Eastwood movies stuff. I do tell them when we are retained to do investigations, I do tell the company, look, we do thorough investigations. We will find out what went on. We're good at what we do. We know how to question witnesses, but we're going to find out things that are pleasant, things that are unpleasant, and so on. And I often use the term the good, the bad, and the ugly. And I think that the companies, they understand that. I think from the company's standpoint, for them, one of the benefits of the investigation being that it's, usually before litigation, it's when everybody's mind is fresh, is that it's almost like discovery in litigation taken before the litigation and not 2 years later when the company goes, gosh, if I knew that 2 years ago, yeah, before we spent hundreds of $1,000s in defending the litigation, we might have handled things differently. So the idea is that we're providing the company with what's they might like to hear and also what they might not like to hear. The interviews themselves always a one-on-one. I do not allow company representatives to sit in on the interviews. I don't think I've ever been asked to do that. The only exceptions would be if you go down the bullet point about counsel. If the witness, and particularly this would be a complainant or an accused, if they have counsel and they want their counsel present at the interview, or the counsel insists on being present in the interview, the counsel is going to be present. I'm not going to interview someone who has counsel without their counsel there. There have been times where I've had complainants who will say that they have counsel, but they don't tell me who the counsel is. And I would ask them, well, okay, your counsel definitely can be present at the interview if you want. In fact, I will contact your counsel if you give me the name. They don't give me a name, I presume either they really haven't retained counsel. And in some instances, you go ahead and say the complainant will say, no, I will go ahead with the interview without counsel. In that instance, I will do the interview, but that's an area that I think to be very careful. If the witness, the complainant has counsel, have the counsel there. Now, I do have some rules for the counsel. You can be there, but look, this is not a deposition, and I don't want deposition type objections. Basically, what I will tell the counsel representing the witness, at any time that you want to take a break, discuss things with your client, we will do so. No questions asked. I'm not going to say, you got to answer that last question before we can break, as I might do at a deposition. No, you break, you talk to your client, and when the client comes back to further talk to me, I'm not going to say, what did you and your counsel just talk about while you were outside? And I have found over the years that the counsel have been very, very cooperative. There's an issue of recording. Well, let's go first. Where do we do the interview? Since COVID, and the remote video interviews are very much accepted. And in many, many instances, that makes sense. It makes sense from a logistics standpoint. It makes sense from a cost standpoint. I'm still a little old-fashioned in the sense that if it's practical for me to do the interviews of the complainant and the accused in person, I will do that. The body language that you can get in a room where you're together is sometimes a little different than what you can get remotely. In terms of recording, I've gone through over the years wanting to record, not wanting to record. First of all, in California, consent is required. And there are times where I've asked complainant, would you agree for me to record it? And the complainant says, nope, it's not going to be recorded. And in many instances, I've really decided I don't even ask that. I just don't do it. I did have one bad experience where I interviewed an accused. And it was in person. I did not ask the accused if I could record. I did not record. And I found out, subsequent to the investigation, and I think in that instance, maybe the accused was terminated. The accused had recorded the conversation on his phone. Obviously, I wasn't very happy about that. Nothing more came of it, but that's a risk you run, particularly when you do these. That was in person. The guy had this record on his phone, and I didn't know it. It could happen. In terms of sequence of interviews, I wouldn't say every time, but most of the time, start with the complainant because you want to expand on what the allegations are and get a good idea of some of the details, who the complainant believes are witnesses, what documentation there is, and so on. I feel that for the purpose of these interviews, that I can't wear my deposition hat. I am wearing it's a much different demeanor. The demeanor is, I want to get as much information as I can. And so it's a very friendly conversation. In fact, I flat out tell each witness that this is not a question and answer period. This is not like I have 20 questions and I want you to say yes, sir, or no, sir, to each question and maybe elaborate some. I make it very clear that it's an open-ended discussion. I tell the witness, look, you'll get some understanding of what I'm probing about, and feel free to bring up whatever you think might be pertinent to the discussion. And don't hesitate, and don't feel like you're wasting my time. If you're going astray, I'll let you know, but please, I want you to talk. And I'm pretty good at it. I mean, I get people to talk, and often, particularly with complainants, and sometimes with accused, and sometimes with collateral witnesses. It takes a while to build a rapport, to build a trust. And at times, when these interviews go on 5, 6, 7 hours, and by the end of the interview, they feel relaxed. They've told you, they feel relaxed enough to tell you everything. At the end of these interviews, by the way, I do tell every witness, you have my contact. I give them my contact information. If there is anything else you can think of, or you have any documents or whatever, here's my contact information. You may contact me. You can contact me by email. You can contact me by phone. And that that right for you to get back to me and provide me with more information or call me, that goes until the time I finish my investigation. Let's go on to the challenging interview issues. And first one is I put the complainant or accused represented counsel. I think I've already expressed there's no question in my mind that the one counsel present, I'm going to allow that. And sometimes I will discuss it with the company, and I've never had a company tell me no, they shouldn't be allowed to be represented by counsel. Collateral witnesses, what do you tell them? It's a toughie because you've got privacy issues. You're trying to keep the information about the investigation somewhat confined, somewhat confidential, but it's tough. It's very tough to question someone who may be kind of an observer of an alleged incident and not, give them some idea of what you're asking about. And so I will start with the open-ended questions, but it does sometimes get to a point where you have to be a little more focused. Sometimes, to say, who is involved. Again, the idea is you're trying to get information, and you need to make judgments along the road with some of these witnesses is how much information that you provide them, because if you don't tell them anything, it's very tough to question them and to get the kind of information you need. Next thing, what if the witness brings up something that is beyond the scope of the investigation? I'm sure every investigator has faced that. When you're talking with a witness and they go, by the way, I got this gripe about this person. Sometimes it's the same person who the complainant had a gripe about. Sometimes it's a gripe about the complaint. It's a number of different things. Sometimes it has to do with some practice of how the company treats people generally. In those instances, I'm certainly going to take enough information so I have some idea of what their concern is. But of course, I've got to go back to the company and say, look, this was brought up. I have a duty to provide them whatever information has been provided me by witnesses. And then it's really up to the company as to whether or not to start a new investigation, expand the investigation, or not have me do anything further. How to handle a reluctant witness. With witnesses, basically, we're not judges. We can't subpoena people. We can't compel them to testify. I see my greatest ability is in kind of persuading people to talk to me. But if they don't want to be involved in an interview, I will never threaten anyone. I will never coerce them. If it's an employee of the company, I will certainly advise the company that I wasn't able to talk to this individual because they wouldn't speak to me, and leave it to the company to handle it as they see fit. There have also been situations where, at some point in the interview, someone says, I don't want to discuss this any further. I won't go any further. And the interview ends. Again, there's no coercion. I have no subpoena power. I don't want the witness to even believe that I have any ability to force them to speak with me. Okay, next, and let's discuss reports. And reports, I never know when I start an investigation how the report is going to be formatted. I don't even know whether it's going to be a verbal report, a written report, or both. The report obviously is very important, and the report, sometimes there are interim reports, particularly with longer investigations, where the company, often if they have a general counsel or a fairly high level HR person, may contact me as to where things stand and so on. But it's that final report that's really what we're talking about here. And the way I view it, and I think this is the proper way to review what our report concludes, or the findings, that our job is to take the allegations, determine credibility or lack of credibility of the allegations, the weight of the evidence. Does it support the allegations? In our view, certainly you're using your legal brain or not, and to make factual conclusions. What our job is not is to inform the company whether we think there has been a violation of law. That, to me, is the province of the company's management counsel or general counsel after the report is provided, in terms of what action to take, and then assessing what the risks are. That's a management function. And so we, as investigators, stay clear of that. We will not provide legal conclusions. Sometimes I think the company representatives that we deal with don't always understand that. And we have to explain, no, that is something you have to do with your management counsel. In terms of whether the report is verbal or written, that's up to the company. I mean, sometimes the verbal report it is sufficient. Sometimes the matters that were complained of, maybe the accused has resigned during the course of the investigation or whatever, and so they don't feel that it's worth the additional cost of having us do the written report at that time. And if so, then we're prepared to do a written report later, but that's where we leave. In the report itself, I said I don't have a fixed format, but I do have certain things that I put in every report. The report starts with we were contacted by the company to investigate, identifies the complaint. I probably will paraphrase or maybe quote from the complaint, indicate when we started the investigation. And then I will list out every single witness that interviewed, when I interviewed them, how I interviewed them. What I mean by that, was it in person or remotely? And then I will list every single document that I reviewed during the course of the investigation. And what we do is we use the old Bates number system, so each document is identified by the Bates number. And then after that, then it gets to the information that was acquired during the investigation, both documentary and by interviews. And that's where things vary. Sometimes I feel that it's best to do it witness by witness, what the witness said. Sometimes the only witnesses that I will have that kind of detail will be the complainant and the accused. And sometimes I don't do that at all. I just do it by issue, and then put in by issue or by, say, subject matter, what the complainant said, what the accused said, what Ms. XYZ said, what Mr. ABC said. It's hard to say why I do it each way a little bit differently, but I have it's experience and it's instinction, and it's how I feel I can best report to the company in a fashion that the report is most meaningful. Certainly the report, is I will identify the issues investigated. I do make credibility assessments, and I make the factual findings. The factual findings are basically that as to each of the issues investigated, does the evidence that was obtained during the investigation, support or substantiate the allegations or not, and if so, why? And if not, why not? I do the report in a draft fashion. Send it to the company and to usually to its counsel as well. And the purpose is for them to review it to make sure that I've covered all the issues. They need further investigation. If the clarifications are needed, there will be some opportunity for the company, particularly if there's some of the witnesses may be asked about are they the information that, if I properly paraphrase what I was told, but definitely it's not a time for the company or the company's counsel to say, we don't like your findings, or we don't like this or that. I must say that I have never, I've been at least 150, but I've never been asked by a company or company's counsel to change the findings or change the facts on which I based the findings. I think they understand that that's something, that's what the investigator does. And let's go to post-investigation. And post-investigation here, as I said recently, I prepared for a deposition, and I was happy to be able to go through all of the file and feel, based on the file, that I had done, I think, a pretty thorough job, as the documents I had well documented the investigation. And you just don't know after the investigations, and I make my report. Very frequently, I have no idea what the company does, what action they take, if any. I don't inquire. Often the company then doesn't tell me. Certainly, if there is litigation later on and I'm contacted, then sure, I'll find out. But frequently I deliver my report. I'm done. I'm out of the loop. However, I'm certainly available as things come up. I've been called during mediations, litigation mediations. Okay, we're in mediation right now. Can we've been showing the mediator your report, and this, can you elaborate on this a little bit for us so you can find this document? So I'm available for that. Of course, if there is litigation, then I will be involved in responding to subpoenas for our records. When such a subpoena is sent, of course, since the attorney-client privilege lies with the client, I leave it to the company and their counsel to object to the subpoena if they so choose, and will not respond in any way until I get clarification and authorization from the company. I think,
And just a heads up, we have about 10 minutes left. So
okay.
if you could save a few minutes for questions.
And in most instances, I think that the company just produce the entire file. But it's their privilege. And then there certainly is the possibility of there being, actually giving a deposition and being a trial witness. And so obviously you can be prepared for that. And as I say, since the litigation is often years after you've done the investigation, and you need to go back to your file and you need to get read through that file carefully, basically reacquaint yourself with the facts and to refresh your memory. And then I just have this one last slide, what I call earmarks of a quality investigation. I just put 4 points. The investigation should be prompt but thorough. I think that's key. That's what's, the court decisions say. That's what the regulations say. I give the witnesses, particularly the complainant and the accused, very wide latitude to speak. Tell me whatever they want. Tell me their stories. I don't belittle them. I don't discourage them. In fact, I encourage them. And I want to hear it all. You make efforts to interview as many witnesses who seem potentially have information that would help you probe the credibility or the evidence on the allegations. And then finally, on the report, there's two things. You want to communicate to the company the process you used and the findings, and in so doing so, and the findings, that there's an analysis applying the facts to the allegations in the complaint. Okay. All right.
Thank you. That was such a great breakdown of the process. I want to kick it off with a question, because I've never allowed a witness to review my notes to comment. Has that ever backfired for you?
No, it never has. If I'm ever in a position where I'm being questioned about that, I feel like I can rely on my notes. I can say with a straight face, I took these notes, I read them to the witness, and I've got this acknowledgement form signed by the witness, and I'll stand by that. I'm sure there could become a time where that becomes an issue, but I feel very comfortable with that process.
Do you allow them to take the notes after the interview to spend time on it, or it has to be done right then and there?
No, I do not give them the notes. I do not actually show them the notes. I read them the notes. And I mean, basically read them the notes verbatim.
Oh, okay. All right, does anyone else have questions? I don't see any in the chat, but if you'd like to unmute yourself, maybe we can take the shared screen off so we can have a gallery view.
I have a question. This is Linda. Is it always the case that the people are still working for the company that you're interviewing, or have they already possibly left the employer because they don't want to be supposed in a hostile environment? Have you interviewed people who are no longer actually at the workplace?
The answer is yes. There will be investigations where I will interview non-employees. But that's a call for the company, because the investigations, by their very nature, are supposed to be confidential. In my interview forms, I actually put in there, please do not discuss what our interview with anybody else. Basically, you don't want them to influence anyone else. And so to go and interview someone who's no longer with the company doesn't have any control over, that can be a little dicey. And so that's a call. But sometimes these are important witnesses. It's different than in litigation, where when you're in litigation, you're out 2 years out from the incidents that are being litigated over. And a lot of the people have left. I mean, they didn't leave because of the investigation. They just left in the natural course of events. And then you got to, kind of find them and question them. The beauty of the investigation, these workplace investigations, they're being done contemporaneously. So most of the people are still there. And because they're still there, they work for the company, and the access to them is pretty good.
And
Can you hit stop share on your screen?
There we go.
there you go.
Great. Does anyone else have a question? You can unmute yourself and ask. Don't be shy.
And if you have questions, you do have my contact information on the slides, and just contact me.
I have another question, if no one else does. If the complainant is reluctant to talk to you, how do you convince them that it's perhaps in their favor, or does not enter into it? How do you compel them to talk to you honestly?
Well, it's not to talk to me honestly, it's to talk to me at all. And I have a number of situations over the years where the complainant would not allow to be interviewed. It's only so much I can do. And I usually will be corresponding with the complainant by email. In other words, I would have my contact person, I say someone in HR, contact the complainant and say that, we have your complaint and we hired an outside investigator, and it's Mr. Rose, and Mr. Rose will be, contacting you to investigate and to speak to you about your allegations. And I'll go ahead and take it from there. And sometimes it's just, we're not sure if they want to talk to me, and it's sometimes it lands up that they will not. But the emails that I would send would be, hey, you made a complaint. I have to investigate it, or I've been hired to investigate it. In order, to do a full investigation, I need to know as much information about your allegations as I can acquire. And you're obviously a very important person to talk to. And, in terms of my conclusions in the investigation or the report and so on, if you don't talk to me, then, essentially I have to make a report where I say the complainant wouldn't speak to me. And so therefore the conclusions that I have, other than maybe if there's a written complaint, really don't take into account what the complainant have to say. And so it's not, it's not going to help the complainant. I mean, if the complainant really wants, if the purpose of the complaint is, we want you to investigate this, and, I want justice, I want to process whatever, and then you're going to back off and you won't cooperate, well, that's not going to help. I would not say this to a complainant, but I would think that in a legal proceeding, if there's ever a legal proceeding, and the complainant sues and they're asked, like, well, you brought this complaint and then you didn't participate in the investigation, that might work in a backfire against the complainant.
Thank you.
All right, well, we're right up on the hour. Ken, our thanks to you for really informative, well done presentation. I think Linda had sent out the slide deck, so
Yes.
Everyone has your contact information. If they need third-party witness investigations to be done, they can contact you. We know they'd be in good hands. Thank you again for participating and doing this for us today.
Thank you very much.
Thanks, everyone. We'll see you next time.
Thank you all. Great presentation. Thank you.